You're using your own daughter to text. And you think you're smarter than everybody. Trying to manipulate everybody and think you're smarter than everybody.
We're here today in the state of Ohio versus Zachary W. Robinson, case number 26 CR 000007. Defendant is present in open court today with his counsel, William Watson. Your Honor, we're here today on a 2-count information that was filed on January 22nd of 2026. Those counts being menacing by stalking, a felony of the 4th degree. Count 2 being violating a protection order, a felony of the 5th degree. It's the state's understanding today that the defendant will waive his right to indictment, will plead guilty to the 2 counts in the information. There's an agreement that the counts do not merge. The defendant would then proceed to sentencing, and there's no sentencing agreement. And that's the state's understanding at this time. Thank you.
Mr. Watson, is that accurate?
Thank you, Your Honor. May it please the court. Yes, that's my understanding of this morning's hearing. I've had a chance to fully pre-try this matter with the prosecutor. I believe full discovery has been provided. I've also had an opportunity to discuss this matter with Mr. Robinson. Excuse me. He has indicated to me that he is prepared to enter a change of plea by way of information as just outlined by the state. First, by entering a plea by way of information, he understands that he's waiving his right to have this case presented to the Lake County Grand Jury. He also understands by entering a change of plea that he's waiving certain constitutional rights and no threats or promises have been made in order for him to do so. And then finally, Your Honor, since he was just sentenced on a prior case, and I know the court has a pre-sentence report, we would waive any updated pre-sentence report and respectfully request to go straight to sentencing.
Thank you. Mr. Robinson, were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your intentions are here this morning?
Yes, Your Honor.
They indicated to the court they believe it's your desire to waive your right to have this case presented to a grand jury and to go ahead and plead guilty to the 2 charges in this information. The court will then, I will do what your lawyer is requesting. I'm going to incorporate the pre-sentence report that was completed previously, so there's no need to do that or update it, and we'll proceed straight to sentencing where there's no agreement between the parties regarding any recommendations for sentencing. Each side is free to recommend to the court whatever sentence they think is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor, most importantly what you want to do today?
Yes, Your Honor.
Let's get started then. How old are you?
I'm 43 years old.
Now, did you receive a copy of the information that was filed in this case? That's the document that sets forth the specific charges you're accused of committing and what you're going to be admitting to?
Yes, sir.
Did you have a chance to look that over?
Yes.
Now, in that information, you're charged with 2 counts. Count 1 alleges, and you're admitting to these, on or between November 18th of 2025 and December 27th of 2025 in Lake County, Ohio, that you did, by engaging in a pattern of conduct, knowingly cause the individual with the initials of NK to believe that you would cause physical harm or mental distress to her or family or household member of hers. You also have previously been convicted or pled guilty to a violation of menacing by stalking, that being in the Lake County Common Pleas Court, 25 CR 1364. That conduct constitutes the offense of menacing by stalking. It's a felony of the 4th degree. Do you understand what you are charged with and pleading guilty to in regards to count 1?
Yes, Your Honor.
Any questions about it?
No, sir.
Now, in count 2, it's alleged on or about December 28th, 2025, in Painesville Township, Lake County, Ohio, that you did recklessly violate a term of a protection order. And it's further alleged that you have previously been convicted or pled guilty to 1 or more violations of violating a protection order, that being in the Menor Municipal Court on December 14th, 2020. That conduct constitutes the offense of violating a protection order. It's a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in regards to count 2?
Yes, sir.
Any questions about that?
No, sir.
Well, before I can accept your guilty plea, then I need to make sure you understand all the rights you're giving up by pleading guilty. And you first of all have the right to have this case presented to a grand jury. So the document I just read to you, as charges, is what's called an information. An information are criminal charges brought by the prosecutor's office without this case having previously been reviewed or considered by a grand jury. Now, what a grand jury is, it's made up of a group of citizens here from Lake County that get together and they meet privately. They meet in secret for the purpose of evaluating evidence in cases to determine whether probable cause exists that someone committed a crime. Probable cause is defined as some evidence that would suggest a person probably committed a criminal offense. Everyone here in Ohio accused of a felony has the right to have a grand jury independently review the evidence in a case and make a decision without the government being involved in that decision, whether someone should be charged or not. You have that right as well. But you can give up that right if you desire and go forward in the charges brought by the prosecutor in this information. And your attorney has indicated he believes that's what you want to do. Is that correct?
Yes, sir.
Well, before I can accept your plea, I need to make sure you acknowledge that here in open court in writing. And I have in my possession here a one-page document called a waiver of indictment, which sets forth what I just explained to you about this grand jury, and that you want to give up that right. My understanding is before I walked out here, you had a chance to look at this document with your lawyer. Is that correct?
Yes.
Mr. Watson, is that accurate? Did you review this with Mr. Robinson? Go over it with him, answer his questions?
Yes, Your Honor, I did review the waiver of indictment form with him. I read it to him. He read it along with me. He indicated he understood it. He signed it, and I signed it in the presence of the prosecutor, Your Honor.
Is that correct, Mr. Robinson?
Yes, sir.
So you reviewed this document?
Yes, sir.
You understand what it says?
Yes.
Any questions for me about it?
No, I do not.
No, your lawyer said you signed it, and it appears that you did. Did you in fact sign it?
Correct.
And you witnessed that too, Ms. Cutts?
Yes, Your Honor.
Very well, I'll make this document part of the record at this point. Mr. Robinson, I'm going to review with you all the other rights you have that you're giving up by pleading guilty. And you, first of all, have a right to a trial, which could be me as a judge where I listen to the evidence and I make the decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial, which would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those 12 jurors would make that ultimate decision. And that ultimate decision reached by the 12 jurors would have to be a unanimous decision, which means all 12 of the jurors would have to agree together, one way or the other, whether you're guilty or not guilty. Do you understand that?
Yes, sir.
Do you understand by pleading guilty or giving up your right to have a trial in this case?
Yes, sir.
Now, if we did have a trial, you would have the right, the prosecutor here would be representing the state of Ohio, and she would have what we call the burden of proof. With her having the burden of proof, what that actually means is that it is her job, or she bears the responsibility, the obligation of proving you guilty before you could ever be found guilty. You're presumed innocent of these charges, and that presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, sir.
Now, when I speak of this burden of proof, since this is a criminal case, that burden is what we refer to as proof beyond a reasonable doubt. Highest burden we have in our justice system. And what it means, it's the amount of the evidence and the quality of that evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or part of these charges beyond any reasonable doubt before you could ever be found guilty of any of these charges. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes, Your Honor.
In order to do that, or at least try to do that, the prosecutor would call witnesses to come to court to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same persons questions. That's called cross-examination. He can ask them anything he wanted to within certain rules. Do you understand that?
Yes.
Do you understand by pleading guilty or giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes, Your Honor.
Now, you'd also have the right at a trial. You can call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you're not required to do that. You don't have no obligation to do that, but you have a right to do that if you want to. Do you understand that?
Yes, Your Honor.
And you further can request the court issue an order, call that order a subpoena. What a subpoena would actually do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they were not willing to come in voluntarily on their own. Do you understand that?
Yes, Your Honor.
You realize you're giving up that right?
Yes, Your Honor.
Now, you also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes, Your Honor.
And since that's your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor here is not allowed to call you as a witness, make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, Your Honor.
Further understand that if we did go to trial and you were found guilty, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that?
Yes, Your Honor.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, Your Honor.
You understand them all?
Yes, Your Honor.
Still want to plead guilty?
Yes, Your Honor.
You understand your guilty plea is a complete admission of guilt. It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue that you didn't do this or it's someone else's fault or anything like that. Do you understand that?
Yes, Your Honor.
Further, as a result of pleading guilty, the effect of that plea is you'll be found guilty by the court, and then you'll subsequently be sentenced by the court. Do you understand that?
Yes, Your Honor.
Now, as far as sentencing goes, you're pleading guilty to 2 charges, separate offenses. Count 1 is a felony of the 4th degree. That's the menacing by stalking charge. That carries with it a possible term in prison of a minimum of 6 months, a maximum of 18 months, or any whole number in that range of 6 to 18. Do you understand that?
Yes, Your Honor.
Count 2 is a felony of the 5th degree. That's the violating protection order charge. That carries with it a possible term in prison of a minimum of 6 months, maximum of 12 months, or any whole number in that range of 6 to 12. Do you understand that?
Yes, Your Honor.
Now, since these are 2 separate offenses, different time periods, different conduct, if I impose a prison sentence, I would impose it on each count. Then as the judge, I have the discretion to run these prison terms either concurrent or consecutive to each other. Concurrent means together at the same time. You'd serve them both at the same time. Consecutive means one after the other. You'd serve the prison term on count 1 first, finish it, then serve the prison term on count 2. Do you understand the difference there?
Yes, sir.
So in this particular case, if I impose the maximum sentence on each count and ran them consecutive, you're looking at a maximum possible prison term in this case of 30 months or 2.5 years in prison. You understand that?
Yes, sir.
Now, I'm also aware, obviously, that you are currently serving a prison sentence that you were sentenced to here a few weeks ago. If I impose a prison sentence in this case, as the judge, I had the discretion to run whatever prison sentence is imposed in this case concurrent or consecutive to the prison sentence you're currently serving that was imposed, again, previously. You understand that?
Yes, Your Honor.
So what that would mean if it was consecutive is that you'd serve the other prison term, finish that, then serve this prison term. If it was concurrent, you'd serve them both at the same time.
Okay. Yes, sir.
Any questions about that?
No, Your Honor.
Now, if a prison term is imposed in this case upon your release from prison, you could be placed in what is called post-release control, sometimes called parole or PRC. It's a period of supervision you would be on after you complete the prison sentence. And in this particular case, it could be up to 2 years. It's for the parole authority to determine that. I have no involvement with that. You understand that?
Yes, Your Honor.
And if you are put on post-release control and you're violating the conditions of your supervision, we would have a hearing to see if you're what's called a probation. Excuse me, I'm sorry, I jumped ahead. If you were on post-release control and you're violating the conditions, the parole authority would have a hearing. And if they determine that you violated their rules, they could return you to prison as punishment for violating their rules or conditions for another 9 months for each separate violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by this court. Do you understand that?
Yes, Your Honor.
Now, aside from the possible prison sentence, there's other sanctions that could be ordered. You could be fined up to $2,500 on count 2, up to $5,000 on count 1, so a maximum fine of $7,500. Do you understand that?
Yes, Your Honor.
You could also be ordered to pay court costs, or reimburse the county for any costs of confinement, community supervision, or treatment if any of that were applicable. Do you understand that?
Yes, Your Honor.
You could also be ordered to pay restitution to any victim for any economic loss any victim may have suffered as a result of the conduct involved. Do you understand that?
Yes, Your Honor.
Now, a few moments ago, I explained the possible prison term. I did use the word possible. Prison's not mandatory with this offense. These offenses technically are probationable, or you can be put on what's called community control sanctions. Do you understand that?
Yes, Your Honor.
Do you understand that just because you're eligible for community control sanction with these charges doesn't mean that would happen automatically? It means I would consider that if that's what you were asking for. I'd look at all the information presented, then I'd make the decision I thought was the right thing to do. Do you understand that?
Yes, Your Honor.
Now, if you are put on community control sanctions, it could be for up to 5 years. I have the discretion to impose a variety of rules or conditions for you to follow, which could include that you serve a term in the Lake County Jail of up to 6 months. Do you understand that?
Yes, Your Honor.
Lastly, when we do proceed to sentencing, you're going to have the right at that time to say anything you want. Anything you want me to know or consider. Let me back up for a second. If a prison sentence is imposed, you would be eligible for what is called judicial release. That's a motion you request with the court, requesting to be released from prison early and put on a period of probation. You are eligible for that after you've served this particular amount of time, and that particular amount of time depends on how long your prison sentence is. Do you understand that just because you're eligible doesn't mean that's automatic? It means you have a right to file it, but it's ultimately up to me to decide that, and you don't automatically get judicial release. Do you understand that?
Yes, Your Honor.
Lastly, when we do proceed to sentencing, you're going to have the right at that time to say anything you want me to know or consider. Your lawyer could speak on your behalf. He can recommend the sentence to the court. The prosecutor can also recommend the sentence to the court. Do you understand that?
Yes, Your Honor.
Do Do you understand that whatever anyone recommends at the time of sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to follow that if I don't think that's the right thing to do. Do you understand that?
Yes, Your Honor.
All right. Well, do you have any questions for me regarding the potential penalties you face by pleading guilty?
No, I do not, Your Honor.
You understand all the possible consequences?
Yes, sir.
Do you still want to plead guilty?
Yes, I do.
Have you had enough time to discuss this case with your lawyer and have him review the report with you, the case, and answer your questions?
Yes, sir.
Has he or anyone made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty?
No, I have not.
Have you been threatened or coerced in any way to plead guilty?
No, sir.
Are you entering the guilty plea freely and voluntarily?
Yes, I am, sir.
All right, do you have any questions for me at this time regarding anything we've just talked about, what you're pleading to, the penalties you face, the rights you're giving up? Any questions regarding that?
No, I do not, sir.
Do you need any more time to speak to your lawyer before we go forward with your plea?
No, I do not, Your Honor.
Then what's going to happen at this point? The prosecutor is going to explain for me what she believes the evidence would establish at a trial regarding each of the two counts. I want you to listen to her because now I'm going to have some follow-up questions for you. Ms. Cutts?
Thank you, Your Honor. Had this matter proceeded to trial, the state would have proven beyond a reasonable doubt that on November 17, 2025, the defendant, Zachary Robinson, entered pleas of guilty by way of information in Lake County Court of Common Pleas, case number 25CR001364. One of those counts that he pled guilty to was menacing by stalking, a misdemeanor of the first degree in violation of 2903.211A1. After that plea was entered, he was out on bond. During that time frame, he made various contacts with Nicole Knapp, going to her new job, calling her repeatedly, calling family members, causing her mental distress, determine if he was going to show up at her house, when he was going to call, what was going to happen if he would show up at her job. On December 28th of 2025, Lake County Sheriff's Office was called shortly before noon to speak with Nicole Knapp for a violation of a protection order that had occurred at her residence at 1575 Clipper Cove in Painesville Township, Lake County, Ohio. Officers met with Ms. Knapp, who indicated that she and her 19-year-old son were getting ready to leave the house, had gone to the car that was in the driveway. Initially, she went out before her son, and Zachary Robinson, the defendant, exited a vehicle that was parked down the street, approached her and her car, questioned her, made comments such as that she was concerned with. Her son did come out of the house at that point. There was more interaction until the defendant left that location. While law enforcement was speaking with Ms. Knapp, the defendant continued to call her on her phone and text her, which the deputy was able to see. Both Ms. Knapp and her 19-year-old son are both protected parties in a civil stalking protection order out of the Lake County Court of Common Pleas, 25 CS 001682. The defendant was served with that on September 16th of 2025, and he does have a prior conviction for violating a protection order out of the Menor Municipal Court in 20 CRB 00431, dated December 14th of 2020. Officers did reach out to the defendant. He indicated that he should not have gone to her house. That is the evidence the state would have provided, all occurring in Lake County, Ohio. Thank you.
Thank you. Mr. Robinson, were you able to hear what the prosecutor had to say regarding what she believes the evidence would show if we had a trial?
Yes, Your Honor.
What, if anything, do you have to say about those facts she presented them? Are they true? Did you do what she said?
Yes, Your Honor.
Very well. Regarding count one, charging you with menacing by stalking, a felony of the fourth degree, what is your plea to that count?
Guilty, Your Honor.
Regarding count two, charging with violating a protection order, a felony of the fifth degree, what is your plea to that count?
Guilty, Your Honor.
I have in my possession here a 4-page document called a written plea of guilty and judgment entry, which explains everything I've just explained to you. Before I can accept your plea, I need to make sure you understand this document, that you signed it here in open court. My understanding is before I walked out here, you had a chance to go over this document with your lawyer. Is that correct?
Yes, Your Honor.
Mr. Watson, is that accurate? Did you review this with your client and explain it to him?
Yes, Your Honor, I did review the written plea of guilty form with Mr. Robinson. I read it. He read along with me. He indicated he understood it. He signed it, and I signed it in the presence of the prosecutor, Your Honor.
Is that correct, Mr. Robinson?
Yes, Your Honor.
So you reviewed the document and you understand it?
Indeed, I did, yes.
And it appears you signed it like your lawyer said. Did you sign it?
Yes, Your Honor.
You witnessed that, Ms. Cutts?
Yes, Your Honor.
Very well, then the court will accept the defendant's oral and written plea of guilty. Let the record reflect defendant was here in open court with his lawyer advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver of those rights. Court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of count 1, menacing by stalking, a felony of the 4th degree in violation of 2903.211A1, as well as count 2, violating a protection order, a felony of the 5th degree, violation of 2919.27A2. I will incorporate the pre-sentence report that was completed in case 25 CR 1364. And with doing that, Mr. Watson, is there any reason not to proceed to sentencing in this case?
No, Your Honor.
Is there anything you want to say on behalf of your client?
Extremely brief, Your Honor. I know we were just here a few weeks ago on a case, essentially the exact same thing, same victim. My client is remorseful. He obviously has some serious problems. He's already facing some time, and yet he's going to be facing more time in just a moment here. I'm respectfully asking the court to consider the fact that he is taking full responsibility for his actions, especially on this case. This has moved along very quickly. He didn't deny anything with me. He said, yes, I did it, and I want to take responsibility. So, we're here today, Your Honor, hat in hand. He does have a daughter of his own. It has nothing to do with the victim in this case, and she's still young. And he expressed to me that he's hoping that he still has a chance to see her while she's still in high school. So I'm respectfully asking the court to take those factors into consideration and impose a sentence it feels appropriate. Thank you, Your Honor.
Thank you. Mr. Robinson, you have the right to address this court before your sentence. You can say anything you want. Is there anything you want to say at this time?
Yes, Your Honor. I realize that her and I cannot be together. It's horribly toxic, and I need to work on myself, and I want to just be a father to my daughter, and I want to put this behind me and start working on myself. Thank you, Your Honor.
Mr. Watson, anything else?
Nothing further, Your Honor.
Ms. Cutts for the state.
Thank you, Your Honor. As this court is aware, obviously the facts were just put on the record about what was occurring in this situation. What makes this even more concerning to the state is the defendant had just been in the court to plead guilty to telecommunications harassment for calling the victim over and over, as well as menacing by stalking for all of his behaviors and going to her house and things of that nature. He was in jail for a period of time serving a municipal court sentence. When he got out and then pled in this case, he resumed his activities of calling her, of calling family members, of going to a new job, and then to the point of going to her home. There is a protection order in place that covers her and her children. Both she and one of her sons was outside when the defendant was approached yelling, spit on her. The police were called. She had indicated that she had not called sooner, just trying to keep things calm, but once he actually came to her residence and her child was involved, she felt she had to notify the police. So the defendant, that happened on the 28th, he was sentenced in this court on the 29th on the first case. Upon leaving, once he was sentenced here, he had been arrested on the new case that he's pleading to today, and he was sentenced to prison, so he was taken back into custody. Once he was back in the jail, he began messaging the victim's sister, asking the sister to make contact with the victim in violation of protection order, asking her to convey messages, to set up a phone call. We have those messaging from the jail. He also wanted the sister to pick up a telephone so that there could be another way to have contact with the victim. She did do that, though then in messages seemed to regret doing that. The victim also was receiving phone calls from a person would call her, and when she answered, the defendant's voice would come on indicating a three-way call from the jail, which one is a violation of protection order and is also not allowed through the jail to make three-way calls. Also learned that the phone that was the sister picked up and gave to Ms. Knapp, the defendant's, I believe, 13-year-old daughter, was texting the victim about her father and putting her in an uncomfortable position in that situation. So this has been an ongoing situation. The victim finally got a protection order. The defendant has not stopped. The only time the state is aware of a bit of a time off was when he was in jail in the September to November time frame. She's worried about her children who are also on the protection order. She is concerned that he's manipulating her family. He has contact with the sister. Apparently the sister and mother don't know everything that has been occurring. She hasn't told them, so they don't understand the concern when he reaches out to them. Obviously, the relationship with the victim has facilitated these offenses. They've known each other almost 3 years and had various stages of relationships. So every step of the way, he has disregarded both this court's orders as well as the protection order that was put into place. I know the court is aware of his criminal convictions going back to 2000. He has been sentenced to prison in the last case. He's had multiple probation violations throughout his history of drug convictions, misuse of credit cards, assaults, telecommunications, harassment, violent protection orders, escape. He does have a warrant out of Parma Municipal Court. He's on probation with Parma Municipal Court. He has had issues in the jail previously as well as recently with finding contraband. So he's not responded favorably in the past, previous sanctions. We do feel that prison is consistent and he's not amenable. We would ask for consecutive prison since these are occurred after the other incidents. Based on his history of criminal convictions, we believe, the state believes that would be necessary, as well as when he committed this offense, he was awaiting sentencing and was on bond in 25 CR 1364. He would have no credit in this case. He was officially arrested on December 29th and given an OR bond on December 30th. However, he was serving the other sentence, so that credit, that would go to that case. So that is the state's recommendation at this time. Thank you.
Thank you. So, Mr. Robinson, I'm interested in learning when you finally made the decision that you're going to need to forget about her and move on, because that hasn't happened unless it happened overnight. But it had to happen within the wee hours of the night because we're attempting to do that just yesterday. When did you make this decision to move on without her? Because you're not doing that. You're using your own daughter to text. I mean, you think you're smarter than everybody. They have the ability to listen to phone calls, to read text messages. Maybe you don't think they do that, but they do it. They hear your messages with your daughter, dictating to her what you should type out, the stories that you come up with everybody. Aside from that, you get yourself in trouble. You're in the hole right now for 10 days. Now, you could tell everybody it's for having condiments that you weren't supposed to have, but you know the real reason why you're in there. It's just not going to stop. And again, you try to manipulate everybody and think you're smarter than everybody, and just keep digging yourself a deeper and deeper hole. I've considered the prior pre-sentence report and investigation. I've considered the prior victim impact statement. I received a letter from you just a few days ago. I read that and considered that. I considered the facts and circumstances of this offense, the nature of this offense, what's been said here in court. All this is considered only the purposes and principles of felony sentencing set forth in 29-2911. As for the factors in 29-2912, court finds victim suffered serious psychological harm as a result of the conduct involved. Again, as I mentioned last time, and it applies again, this time it's the sheer volume of the attempts for the menacing by stalking. Nothing makes it less serious. As for recidivism, the defendant has a history of criminal convictions. He was on probation to the Parma Municipal Court when this happened. He was on bond to this court, released awaiting sentencing when this happened. No genuine remorse. I mean, he can say what he wants to say, but his conduct does not indicate genuine remorse. His behavior in jail and discipline that he receives is a factor indicating recidivism is more likely. He can't follow the rules in jail. He does what he wants to do. It doesn't matter what anybody says. That's clear. It doesn't matter what anyone in any position of authority says. Those are all factors indicating recidivism is more likely. Nothing makes it less likely. This is just going to continue whenever he has the chance to do it. The 2913B1, again, the court finds the defendant was on probation at the time he committed the offense. And he's on bond awaiting sentencing in this case. Prison is consistent with the purposes and principles of sentencing, and the defendant's not amenable to community control sanctions. Therefore, it will be the sentence of this court that on count 1, charge of menacing by stalking, defendant served a term in prison of 13 months. On count 2, he served a term in prison of 11 months. I'll run those 2 counts concurrent with each other, but this term will be served consecutive to the prison term imposed in 25 CR 1364. There's no credit on this case in as much as it is being served consecutive. These are separate offenses, unrelated to the offense for which he was here for. The court finds consecutive sentences are necessary to protect the public from future crime and to punish the offender. It's not disproportionate to the seriousness of his conduct and to the danger he poses to the public. And he committed the offenses in this particular case while he was awaiting sentencing in the other case, and while he was on probation at the Department of Municipal Court. I need to advise you upon your release from prison. In this case, you can be placed on post-release control for up to 2 years. If you are and you violate any of those conditions, the parole authority can return you to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the prison term imposed. Any additional prison term imposed for violating post-release control is being imposed as a part of the sentence at this time. Defendant's ordered to pay all costs. And the court disapproves of the defendant's placement in a program of shock incarceration, intensive prison program, or TC, or transitional control. I think that covers everything. Ms. Cutts, is there anything else for the record?
No, thank you, Your Honor.
In the state of Ohio versus Zachary W. Robinson, the defendant pleaded guilty to menacing by stalking under Ohio Revised Code 2903.211 and violating a protection order under Ohio Revised Code 2919.27. The court accepted the plea after a full advisement of rights and incorporated a prior pre-sentence investigation. Applying Ohio's felony sentencing statutes, including Revised Code 2929.11 and 2929.12, the court found the defendant was not amenable to community control and that the victim suffered serious psychological harm. The judge sentenced Robinson to 13 months in prison on the stalking charge and 11 months on the protection order violation to be served concurrently with each other but consecutive to a previously imposed prison sentence in a separate case. The court further advised that Robinson may be subject to post-release control upon release and ordered him to pay court costs. The judge also noted the defendant's repeated violations, prior convictions, and continued contact with protected parties, finding that lesser sanctions had failed. The sentence reflects the court's conclusion that prison was necessary to protect the public, deter future misconduct, and enforce compliance with court orders.